Hey, Brandon.
Yeah.
Hey, how's your complaint with the IRS going?
It's going a little slower than I would have liked. The DOJ on my first presentment that I made to them decided they were going to delay picking up the first presentment as long as they could. So rather than them receiving it within a timely manner, they refused it and then picked it up like 2 weeks later from the post office. So it's delayed my entire process. I was actually about to send out, on Monday I was going to send out my second step. And because even if they refuse it, let me give you an example. IRS sends you certified mail and you don't accept it, or you get the card in your mailbox and you don't go pick it up, well, guess what? You
still
faulted. Yeah.
What now?
The fact that you never got the envelope doesn't matter. The fact is they left a notice for you to get it, the post office did, and you never went and got it. And that's all the IRS needs in order to perfect their claim against you, whether it be, let's say it was a notice of lien, because that's the kind of things they like to send by certified mail. So they send you a notice of lien. And that notice of lien, once they've verified that a notice was left by the post office, whether or not you pick up that envelope is immaterial and irrelevant. They will continue 10 days later after the notice is left with their process. So I was going to continue with my process because I didn't care whether or not they got the envelope or not. But then as soon as I saw they got the envelope on Monday, literally the day I was about to send in my step 2, I decided, okay, I got to hold back, wait a few days, and allow some time for them to respond.
Well, isn't your second notice just a reiteration of your first one?
No, my second step is going to be putting them in fault, and is also going to be the foundation for my claim that I file into the court.
Oh, okay.
Once they're in fault, I've got a claim against them, and I counterclaim in my notice of fault.
So aren't you coming up against them as a libelant or something, you said?
In the court, yes.
Yeah, okay. Right on. I was just curious.
They're prejudicing my collateral. So I'm going in, I've given them the opportunity to state a claim, a verified claim, and I've provided them with an instrument to set off any debts or obligations or liabilities that they allege. So now it's on them to either provide a verified claim and or discharge their obligations, and if they don't, then they're going to be prejudicing my collateral, which includes the 3 corporations that they've named as defendants in the case. So those 3 corporations, which I have a paramount security interest in all the property and proceeds of those corporations, they'd be prejudicing my interest by not stating a claim or discharging any debts or obligations on them. So now I have a claim because basically I'm going in there with a claim. I've got a claim on this property that you have alleged or purported to have a claim on, yet you have not verified the claim. So I'm going to protect my interest in the property. These corporations are my collateral and property because those 3 corporations have been pledged into a trust for which I am the executive trustee. As the executive trustee of the trust, I have the paramount security interest in all the property and proceeds related to those 3 corporations.
Did you already write out a bond for the court case so you're not the only one that's not bonded?
Yes.
Very good.